And we'll begin with Zamanillo versus Citizens Property Insurance Company. Mr. Feldman.
Good morning. Paul Feltman on behalf of the appellants. I'm here with Brian Costa and Mr. Ben Alvarez. I'd like to reserve 3 minutes.
All right.
Okay. The trial court made an error below by finding that, in effect, this property had to completely collapse and implode in order for the collapse provision to apply in this matter. I know that the court's read the brief, so if there are questions with regard to how we got here, I'm happy to answer them. But I would like to say below that in order to get the summary judgment, the appellee said that the qualifiers did not have to be discussed. It was only the definition of collapse. So, for instance...
doesn't the entire thing turn on that definition?
Yes, it does. And so they said that they don't need to get to causation. It only has to go to the definition. And that with regard to the qualifiers, they don't pertain, Judge. We don't even get to the qualifications if there isn't a collapse in the first place. So
as I understand it, there's a split in authority throughout the country, throughout the state, where some courts, about 50% of them, define collapse as a falling in, loss of shape, or reduction in the size of the premises, whereas the other half of the courts say deal with structural integrity issues, right?
Correct.
So, and you're relying primarily on the 5th District's precedent for the proposition that in Florida right now the prevailing state of the law is that structural integrity is sufficient for collapse.
That's correct.
So your position is that the trial court erred because they didn't follow the precedent that would have been binding in the absence of 3rd District Court of Appeal precedent to the contrary, correct?
That is correct.
Okay.
And the point is that the definition does not require that the building fall and implode to the ground. There are policies that do say that. This one does not. And that's why in the Kings Ridge case, the 5th District looked at that and said, well, if you want to define it that way, you can define it that way. But in this case, it was a bit of a preposterous kind of result for these people, given what happened to their home.
But the qualifier in the policy says if the building or any part of the building is still standing, then it's excluded from the definition of collapse, right? That's really what we're struggling with here, correct?
Yes.
Okay.
But the way that citizens and the way that the trial court defined standing was that it would have to implode and fall to the ground in order for it not to be standing. And that's why in the Kings Ridge case, they said, however, the same may be true for a part of a building that has partially fallen down or caved in. The policy clearly does not require that destruction for a collapse to occur, okay? And that is really the issue.
But the policy in this case says collapse means an abrupt falling down or caving in of a building or any part of a building with the result that the building or any part of a building cannot be occupied for its intended purpose.
That's correct.
So, but you have to read that entire paragraph together, right?
Yes.
So there has to be a collapse or falling down or caving in.
Okay, so that happened when Mrs. Zamanillo was home and she heard an explosion. And it felt like an earthquake, and the whole home fell down. It's 1.5 to 2.5 inches in different areas of the home where it's no longer level there. So that is your caving in, falling down. So that portion of collapse in that definition occurred there.
As opposed to walls caving in and falling down.
Correct.
So you believe that walls caving in and falling down is not necessary to satisfy the definition in the policy of abrupt falling down or caving in. You believe that a settlement of the entire building is sufficient to satisfy that language?
Yes, under the facts of this case, because it is implied within the policy itself that a building may still be standing and yet be in a state of collapse. I mean, that is the case. So, yes, I don't believe that it's necessary.
Can you walk us through that? I apologize.
No. I was just going to ask about the provision about that the building is standing even if separated from another part. So go ahead, yeah.
Can you walk us through that implication? You said the policy implies that the building can still be erect, but in a state of collapse.
Okay, so we're going to the qualifications on that. Okay. Section B. Yeah, the property is no longer standing because it's not at the same level, degree, or amount of height for an indeterminate period of time, which is what they found in Kings Ridge. And so prior to the incident, everything was level, everything was in the same place. There's an explosion, it implodes, and now we have the property itself has collapsed. That occurred. It is no longer standing. As I said, it's 1.5 to 2 inches differential throughout the home. And so if standing is deemed to be the opposite of collapse, then its definition rests entirely on what collapse is defined as. It would have to, so we have to go back to collapse. It's an ambiguity within the policy. So no, it doesn't need to be fallen to the ground. Again, there are policies that say complete implosion, fall to the ground, walls falling down. That would be the definition of collapse. But that is not the case here. It was very clearly written. It doesn't say that. Citizens wants to say that. The trial court did say that and found that. And in trial court's ruling, the trial court said one thing that went a little bit further, and I just want to make sure that's clear. As he got down to the bottom of the ruling, he said, this case is not remotely Kings Ridge. In that case, the court found that the record establishes the building is structurally unsafe and cannot be occupied for its intended purposes. Again, not our situation. First, the policy in this matter does not require that the building be unsafe. The policy provision does not say that. It does not define collapse as that. It says collapse means an abrupt falling down or caving in of a building or any part of a building with the result that the buildings or any part of a building cannot be occupied for its intended purposes. What the trial court did was read from only a portion of Kings Ridge. And it says, and this is what he found there at the end, finally, the record establishes that the building is structurally unsafe and cannot be occupied for its intended purpose. He stopped there. It goes on to say, clearly one cannot occupy a building if it's completely fallen down or caved in. However, the same may be true for a part of a building that has partially fallen down or caved in. The policy does not clearly require total destruction for a collapse to occur. To the extent that the policy can be interpreted as requiring the roof to have fallen to the ground, in that case, the trusses had deflected inward. For coverage to apply, the policy is ambiguous. The same thing here. It didn't say that it had to fall to the ground. And the trial court missed that separate part.
So then you would concede that if the definition of falling down included the walls falling down or caving in, then that would be different, right?
That would be different if they had defined it that way.
If they defined it that way.
Which they did not in this case. And as a public policy matter, there are thousands and thousands of Floridians who've paid premiums for this additional coverage. This coverage stands on its own. It has nothing to do with the rest of the policy. It's collapse coverage, and they've paid for it. And if citizens wants to define it as falling to the ground, then they can, but they didn't. And that's why the 5th District and the other half of the jurisdictions who have looked at this provision has to give it meaning. And in order for it to have meaning, it's not going to say that it has to fall completely to the ground. They could have said that.
Counsel, didn't the evidence show that not only has this bathroom not collapsed or fallen down, but it was still able to be used for its intended purpose? Now, there are complications because when you flush, water could come out of other pipes, but it could still be used for its intended purpose.
No, it cannot, because when the building collapsed, the pipes in the walls all broke. So you have water in the walls. That's next to the bathroom, between the bathroom and the bedroom. So if they turn on the shower, water flows into the bedroom. The toilet does not flush because that pipe also were damaged. If you read the Daubert hearing, and I don't think you probably had time to, but they talk about the bending of the slab like a pencil if you bend it, and this bathroom is in the middle of the property, and so that's why the door's not opening. That's why all these pipes there and the cracks are throughout that area. So that portion of the property cannot be used for its intended purposes. It says any part of the property, and that is a part of the property that cannot be used. And certainly, at a minimum, would have been a question of fact.
All right, thank you.
Thank you.
You went a little bit over on your first 8 minutes, but I will give 11 minutes to your opponent, and then I will give you the full 2 minutes on rebuttal.
Okay. May it please the court, Scott Samers for Appalachia Citizens. I think it's important to understand that this new provision, this definition of collapse, was the result of a bunch of case law because collapse had not been properly defined, and in a lot of cases talked about, well, it's enough if it's structurally unsound or there's some cracking and things like that. So what happened is the carriers went back and they created this new one. And they said, look, when we said collapse, we really mean collapse. It needs to fall down or cave in to the point where the building or part of building can't be occupied for its intended purpose. This building, this house, has been occupied since 2010, since this happened.
But doesn't the policy say any part of the building?
Part of the building, too. So the only part of the building that has, as a practical matter, not been used is the hall bathroom. So that's what we're talking about. The question today really boils down to one question. Is a house that has a broken toilet and a leaky shower in a state of collapse? And in every important way, the answer is no.
Yeah, but again, it doesn't have to be the house. It can be any part of it.
Let's talk about the
So,
bathroom
I mean,
only.
the statement you made really doesn't work with anything.
Yes, well, look, the bathroom is the only part that they say they haven't used. So the whole rest of the house is being occupied. So there's no question there. They haven't used the bathroom, but that doesn't mean it can't be occupied, as Judge Herndon observed. You can open the door and go in the bathroom. You can stand at the sink. You can sit on the toilet. You can go in the shower. It can be occupied.
But isn't there testimony in the record that there were safety issues concerning the plane of the floor based upon the uneven surface that resulted from, presumably from the soil decay, that pressed the floor down at a level that was no longer an even plane?
Right, but the floor can still be occupied for its intended purpose. They said, well, it's uneven, like a sidewalk is uneven. It's still occupied for its intended purpose, and in fact, the only part
But you can
of the
go
house-
into a building where the structural integrity is compromised, the beams that hold up the ceiling, for example, are compromised, and you could make the argument, certainly you can go in for its intended purpose. You can use the bathroom, but you better go in at your own risk and perhaps holding an umbrella, for example.
Well,
I know that's an extreme example.
Right.
But where do we draw the line in terms of whether or not it's safe to, because I think the record evidence said, I think it was Mr. Brizuela who opined that it wasn't safe to occupy it for its intended purpose because of the plane.
all he said was that it's a tripping hazard like any uneven floor. And that's all he said. And they've obviously been using the house. I think that when you start using examples like that, that's where you really are departing from what this court said in Castillo is that you have to look at this language like the man on the street would. What does collapse really mean? What does not being able to occupy a building for its intended purpose really mean? What does standing really mean? And when you look at those words in their plain usage, it is not that, we have a house that has cracks in it and the plumbing, my house is in a state of collapse one time a year because the toilet is not working or there's a leak in a shower. That's not what these words mean. So you have a house that's been occupied. You have a bathroom that can be occupied. There's no dispute that you can go in, occupy all those things. You don't occupy plumbing. That's what's wrong with this house, is the plumbing is the excuse for it not being occupied. Now let's look at standing. Standing, their own expert described the bathroom as standing. The house is standing. I mean, at that point, I think the case is over because even though there are cracks, it is still standing. So let's look at what Kings Ridge and what these cases across the country do. Even if you agree with the analysis in the cases that say, well, we think standing may be ambiguous or something like that, there is an interesting distinction that arises from all these cases. If you look at Kings Ridge, the building was in dangerous and unsafe structural condition. Essentially, the message is when a place is collapsed, you have to go. You have to leave. Malbo Holdings, the hotel had to be evacuated. Nobody was allowed back in. They were going to red tack it and close it. They had to get everybody out until the whole thing was shored back up. That's an understandable ruling. That one you can reconcile with the plain language of words like occupy for the intended purpose, caving in. 130 Slade condo, deteriorated to the point where the column buckled, occupants had to be evacuated. Landmark Realty, unfit for human habitation. Ken Johnson, condemned and ordered vacated. Key Biscayne, uninhabitable. So you see that even the cases that find it, they are at a degree of destruction where you can understand that the plain language of the definition is still being respected. Then you look at the ones that are more like this. You look at the cases where there's cracking throughout the house, there's sagging, there's unevenness, the things that exist in this house. And all of those cases, they say that does not rise to the level of collapse. Collapse means something more extreme, where you can't go in the place. That's not the case in these. In Lambros, there was no collapse because there was nothing to show that the structure was no longer habitable. This entire sort of division you talked about, Your Honor, about the cases across the country was discussed just a couple of months ago. The Connecticut Supreme Court in Gemiola came out with a decision, and they did a survey of all the cases, and they drew the line that I think is easily drawn in this case, and puts this case in the non-collapse category. So,
Do you need to look any further than the exceptions or qualifiers in the policy? Standing, even if it shows evidence of settling, cracking, shifting, bulging, cracking, sagging, said cracking twice. Sagging, bowing, bending, leaning, shrinkage, or expansion?
they really, really
You
mean
need
it.
to go any further than that to resolve that issue?
No, I think that you can, to resolve the issue, first of all, the intended purpose ends the case because the whole entire house can be used for its intended purpose. But just in case there were any doubt, then you can look at the standing, and both experts said this is standing. So even if you only had one and not the other, either one independently removes this from the collapse category.
I have to tell you that, to me, it seems unfair to the insured to make them occupy a house that has all of those deficiencies. But that's the language of the policy, and I'm not here to rewrite that.
That's correct, Your Honor. And you know, you have to understand that in order to write insurance policies, these kinds of restrictive conditions have to be written because there are cases where deterioration or problems that are caused by contractors cause this damage, and that's where the remedy lies. And premiums would be through the roof if all of these kind of cracking cases were covered. It's a practicality. So, you know, these policies are also...
I'm not talking about, I mean,
I
my house was built in 1925, there are cracks everywhere.
Yeah.
I'm not talking about that.
I
I'm
understand.
talking about where there's settling and there's plumbing went out of whack because of the settling and the issues involving a sudden event, which is what was alleged to have happened here, right?
Right. But as Your Honor says, you have to read the policy and interpret the policy by its plain language. You know, the Jefferson insurance case said, and I think this is apt here, that the court should not put a strained and unnatural construction on the terms of a policy in order to create ambiguity and uncertainty. We have words like collapse, occupied, standing, which everybody agreed on. These are words that were put into this policy so that this line can be drawn. And I understand that it's when things aren't covered, people feel sorry for people. But we're here on a contract. This is not a state that has reasonable expectations. It's the language and the black letter of the contract that needs to be followed. And you know, when you look at that, the trial court's decision really makes sense. It respects the language of the contract, because otherwise, I mean, think about if you write an opinion that says this is enough. Then if you have, you know, a shaking or a house settles and something falls off and breaks the stovetop, well, now we can't use, that's what this is. We can't use the plumbing, but you can occupy the kitchen. The stove can't work. Are you really going to accept the argument that the house is in a state of collapse because the stove is broken?
But this is a little different than that example because there's a structural integrity issue with the floor that is revealed through the engineering report that was prepared by the neutral inspection, right?
No, it's not a structural integrity issue. All that he said is that there are parts of the house that they use where it's more than a ½ inch and 10 feet, so it's uneven to the point where maybe it's a tripping hazard. It's not to condemn the house. You don't have to evacuate the house. It's not a structural issue. The house isn't going to fall down or collapse. It's nothing like those cases, nothing like them. And that's why the house has been occupied for 10 years since then without a problem. It really is qualitatively different. You know, the other thing I want to mention, which is in the last minute, is that there's an aspect of the Fifth District's decision which really is a mistake.
The definitional.
The
section.
definitional part. They
We're familiar
really
with it.
did, standing means, in this context, upright on its base. And what they did is they engrafted onto it an alternate definition, which is the same level, degree, or amount for an indeterminate period. That's not the same sense of standing. That's like a standing order or a standing offer. And part of the problem with that opinion, I think that they reached that decision, is that they misread Merriam's dictionary. And that, in fact, the federal court in Illinois that's cited in the brief, they actually pointed out that error in the Kings Ridge case. We don't need that argument to win today, but I think it is important to point out because I think it led them.
Well, American Heritage Dictionary has one definition that says to remain stable, upright, or intact. So I struggled with the word stable. Do you want to address that?
Yeah, I mean, the house is it's been standing for 10 years, and in fact, yes. Mr. Bizuela, the plaintiff's expert, when he was asked, is there any problem? Is this anything more going to happen? He said, no, it's been okay for 6 or 7 years. It's not going anywhere. So that is actually refuted in the record.
That concludes your time. Thank
Thank
you
you.
very much. Mr. Feldman, you have 2 minutes.
Thank you, Your Honor. I want to be very clear. This policy does not require there to be anything of an unsafe structure for it to be condemned or uninhabited. Mr. Brizuela did testify that in the event of a hurricane, which are things that we do have here, that this is a dangerous building for them to be in. So if we're going to look at that, which we don't need to under the terms of this policy, he said if there's a hurricane, this is an unsafe structure. And their expert also agreed.
The definition doesn't talk about an unsafe structure, does it?
It doesn't, but I just heard a couple minutes of discussion about all these other cases from these other jurisdictions, and in those cases, they're talking about unsafe structure, condemned, uninhabitable, because that's in the definition of collapse in those cases. If they wanted to put that in their definition, they could have, because they were clearly aware of all these other jurisdictions who had unsafe in the black letter of the policy. And Your Honor, I understand from one of your questions that you're looking at, well, is this seems unfair, but maybe the policy doesn't say that. The policy does say it. One part of this bathroom, in this house, the bathroom, cannot be used for its intended purposes. There's deflection sloping throughout the slab. It is unsafe to the extent that that even needs to be addressed, which it doesn't, in the event of a hurricane. And so this clearly falls within the definition of collapse in this case. And the reason why the house is not stable is because of this danger from the hurricane and the cracking and sloping throughout the slab. And one of the reasons why I believe the 5th District in Kings Ridge came up with this definition of standing is because the policy is ambiguous. And so to define it requires them and requires this court and required them to give the ambiguity in favor of the insured, which is what the law in the state of Florida requires. It requires that any ambiguity be resolved in favor of
We don't have to define collapse. We have to define abrupt falling down or caving in, because that is a definition the policy gives to collapse, right?
Yes, that's correct. And Mrs. Zamanillo was in the house. She heard an explosion. There was glass shattered, mirrors shattered. There was broken furniture. I mean, this was not just like, oh, it kind of settled a little bit and there were some cracks. This was an explosion and what she heard, and it was tremendous. This was not something that was, it was abrupt and it was severe.
All right, unless my colleagues have any other questions, your time is up.
Thank you.
Thank you very much.
We ask for a reversal and the matter remanded for further
so much.
proceedings. Thank you.
Thank you.